Well, thank you very much, and it's great to at least connect with you virtually. I really a big warm thank you to UCLA Law Promise Institute, and also I understand there are many organizing partners that are really bringing together this very timely discussion. So I think if we look at the world, I think we would all agree that we're really at a crossroads, facing a multitude of challenges and uncertainties. It starts, of course, with the intensity of conflict and violence and wars, but also the deepening inequalities, the geopolitical divisions that really have this potential to erode trust, but also shatter our sense of humanity at the very moment when we need each other most. And of course, the triple planetary crisis of climate change, biodiversity, and pollution, which is frankly no longer a dystopian threat, but is having a devastating impact on lives and livelihoods in the here and now. As you very well know, without immediate and tangible action, the human rights impact of environmental destruction will increase exponentially. Already, 7 million people die each year from pollution alone. Already, extreme weather events that previously would have been unheard of in many places, intense heat waves, droughts, flooding, tropical cyclones, are becoming commonplace, killing thousands and displacing millions. Already, entire ecosystems, the food systems, and the people who depend on them are on the brink of collapse. You probably heard what the Secretary General said recently, that we are all waging a suicidal war on nature. So the only way is to stop and to change. And human rights offer a roadmap. In fact, I would say it is the roadmap for the transformative change that we need to make peace with nature in order to preserve our planet and our future. The human rights framework is universal. It compels us to act, not out of fear, but out of commitment to solutions that are rooted in justice and human dignity, and solutions that will obviously work. As you know, last year, we commemorated the 75th anniversary of the Universal Declaration of Human Rights, which was, as you know, a document produced in the aftermath of profound global trauma and horror. And long before the world knew what we know today about the threat of climate change. But the Declaration's promises still ring just as true and relevant. Amid the many crises we face, it was last year very moving, and despite all the tensions that we have, to actually receive hundreds of pledges from government, civil society, but also the private sector on the Human Rights 75 initiative in December, which also really shows to me, despite all the doom and gloom, that human rights are seen and have the power of and the urgency as a catalyst for change. As an outcome of the rich consultations that we had last year, I offered a vision statement, which we call Human Rights: A Path for the Solutions. If you don't have it, we will definitely make sure we can send it to you. And one of these core messages of this vision statement for human rights in the future is the need for environmental action to be grounded in human rights. And I pointed to several priorities that are, I think, of direct relevance to your own discussions: the normative advancement of the right to a healthy environment, the accountability for environmental harm, the justiciability of the adequacy of government measures to prevent such harm, the empowering of people to exercise their rights safely, and in particular human rights defenders, and an equitable and just transition to sustainable economies and societies. It is encouraging that the search for solutions to climate change continues at pace. But also what we have seen are groundbreaking developments in international law over recent years. And of course, the challenge always remains: how do you put words into action? but we can be encouraged by very concrete progress. As you know, 2022, the General Assembly recognized what we already knew to be true, that all people everywhere have the right to a clean, healthy, and sustainable environment. And since that resolution was adopted, it has been referenced by the UN Environment Assembly, which is, as you know, the world's highest decision-making body on environmental matters. It has also been crucial in outcomes of key climate, biodiversity, and chemical negotiations and judicial decisions. Just to give you the recent example of the Inter-American Court of Human Rights, it found that extensive violations of the right to a healthy environment of the La Oroya community in Peru due to the inadequate regulation of a mine and smelter complex. Some 83% of all member states of the United Nations have now formally recognized the right to a healthy environment in their domestic law. But also discussions about the right to a healthy environment are underway in regional bodies, such as the Council of Europe, but also in ASEAN, which in a way carries the potential to advance a common understanding of this right, but also to strengthen mechanisms for its implementation and enforcement. And these efforts are important. They can provide clarity, they can facilitate the implementation of the right to a healthy environment, but also provide a solid basis to hold governments and businesses accountable for environmental harm. There is no, as such, universally agreed definition of the right to a healthy environment, but it is generally understood to include a number of elements. And it's important to give content to this right and to see how it applies. I mean, obviously, we would not only argue, we would make a strong case that it includes clean air, a safe and stable climate, access to safe water and adequate sanitation, healthy and sustainably produced food, non-toxic environments in which we live, work, study, and play, healthy biodiversity and ecosystems, access to information, access to justice, and the right to participate in decision-making. Many of these elements are rights in and of themselves. So if you could almost argue that you lift these different rights and consolidate them in the right to a healthy environment. Importantly, the right to a healthy environment bridges, it in fact draws tightly together environmental and human rights law and overcomes the fragmentation that we often see in international law more generally. I mean, you probably know there was a big discussion in the International Law Commission many years ago about the fragmentation of international law, but human rights in a way helps us pull the different strands of law together. We also have seen that the Intergovernmental Panel on Climate Change has concluded that a rights-based approach to climate action leads to more sustainable and effective outcomes. We have seen more and more requests for advisory opinions related to climate change before regional and international courts. It was really young people from the Pacific region that worked together with the government of Vanuatu and a multi-stakeholder coalition to have the General Assembly request the International Court of Justice to clarify the obligations and legal and human rights obligations that states have with respect to climate change. The court, as you know, is now deliberating on this opinion. We saw that the governments of Chile and Colombia have initiated a similar process before the Inter-American Court of Human Rights. And only last week, the International Tribunal on the Law of the Sea issued an advisory opinion on climate change and found that anthropogenic greenhouse gas emissions constitute marine pollution and that states have binding obligations to limit temperature rise to no more than 1.5 degrees centigrade. And the tribunal described climate change as an existential threat that posed human rights concerns. And a little over a month ago, the European Court of Human Rights, as you know, ruled in favor of a group of Swiss women who had said that they were at greater risk of dying from heat waves due to weak national climate policies. And the ruling found that states have enforceable human rights obligations on climate change with respect to the right to private life, family life, and home. The court also held that the adequacy of government measures to address the harm due to climate change can be challenged in national courts, which is a major breakthrough, especially for all the countries making up the Council of Europe. And it will, I'm pretty sure, influence other courts in other regions. So we, in a way, see that this growing body of jurisprudence reflects the understanding that the climate crisis is a human rights crisis, and with also a crisis that we are still not doing enough to stop it. But it also shows the power of strategic litigation to actually drive significant shifts in policy and practices of governments and businesses. My office is following all these proceedings very closely. We are also intervening in key instances. So I'm really proud that we are part of this movement that is so central to our shared future. And I would like to thank you all for your own hard work to advance moral, policy, and legal clarity and to enhance accountability. We know that the climate crisis is deeply unjust, disproportionately affecting the world's poor and marginalized, and unleashing its greatest impact on countries and communities that have contributed very little to creating it and often lack adequate resources to address it. Particularly, the impacts of environmental degradation often perpetuate ongoing and historical racism, discrimination, and injustice rooted in the legacies of enslavement and colonialism. It is therefore key that climate policies take into account and combat racial and other forms of discrimination and inequalities. And yet, we see so-called sacrifice zones where poor or marginalized communities are forced to bear a hugely disproportionate burden of industrial pollution, essentially allowing economic growth and profit to trump the rights and health of those who reside there. We see indigenous peoples, from colonial times to the present, denied full enjoyment of their right to development, to their traditional knowledge, and to their lands, territories, and resources, despite the fact that they play a more critical role than ever in protecting ecosystems and biodiversity. And I had a chance to meet with indigenous peoples whenever I do country visits, precisely to learn from them and also to see how we can support them in their fight. The pending advisory opinion on climate change, actually it's not just one, the pending advisory opinions are really excellent opportunities to reinforce the clear duties that states have to protect the human rights of all people without discrimination against the devastating impact of the climate crisis. Securing the right to a clean, healthy, and sustainable environment also requires that we use the tools of the law, including criminal law, more expansively to address environmental harms. I have supported the call to bring the crime of ecocide within the jurisdiction of the International Criminal Court. I welcome the recent establishment by the Office of the Prosecutor of a consultative process on prosecuting environmental degradation through the existing ICC framework. If you look at wars today and how they're being waged, hardly ever do we hear about the massive environmental impact that these wars have. These steps put down a clear marker that environmental crimes should be considered on par with the human impact of other atrocities. But it is indeed true that we need more work to give greater teeth to environmental justice. Those that are responsible for willful and malicious destruction of the environment need to face liability, including in criminal form at national level. A notable step towards criminalization of environmental degradation was recently taken by the European Parliament. It adopted a directive requiring EU member states to impose sanctions and criminal penalties against anyone who causes environmental destruction or widespread and substantial environmental damage. The member states within the EU have about 2 years to transpose the rules into national law. Such recognition of environmental crimes, including the crime of ecocide, by international, regional, and domestic legal systems would really strengthen accountability for environmental harms. It would also speak to people's sense of fundamental justice and that violence against the environment is serious harm to our common good. It would also act as a behavioral deterrent, including for businesses to cease practices which perpetrate environmental harm. We know that environmental crises often have multiple and diverse causes as well as impacts, which calls then also for a multifaceted response when it comes to environmental justice. It's interesting that in a recent resolution, the Human Rights Council requested my office to support the efforts of the government of the Marshall Islands to integrate transitional justice within its national nuclear strategy. As you may know, the people of the Marshall Islands continue to live with the adverse effects of nuclear waste, radiation, and contamination from 67 nuclear weapons tests that were carried out on their islands, including, and it led to displacement and long-term impacts on their health and well-being. And I met representatives from the Marshall Islands who described in great detail what the consequences are. Transitional justice processes also help countries to address the legacy of large-scale human rights violations and abuses. They aim to ensure accountability, serve justice to victims and affected communities, and prevent future violations and harm. But perhaps most importantly, they put victims and affected communities at the center of all efforts so that we really make sure that they can be meaningfully involved in decisions and actions that will impact them. And it has a lot to do also with transitional justice, and we need to see how transitional justice comes into this ambit of environmental justice. And if you go through it, I mean, the first element of transitional justice is truth, which entitles victims and affected communities and the public to seek and obtain all relevant information concerning violations of human rights, including the right to a healthy environment, which means data on climate change, its causes and its impacts. And truth-seeking initiatives should also offer a platform for affected communities to share their experiences, priorities, and concerns. Unfortunately, truth is all too often denied, as we have seen, for example, in the misinformation campaigns of the fossil fuel lobby. Quite a lot have been written about this. The one that always comes to mind is the Merchants of Doubt, especially about the lobbying efforts of the fossil fuel lobby. The second element of transitional justice is justice itself, whether through individual or collective accountability for states, for businesses, for individuals, and other responsible actors. The third element is reparation, which can include individual and collective measures, could take various forms, financial, material, even symbolic. But reparation under international law includes restitution, such as the return of lands, resources, and livelihoods to victims and affected communities. It includes compensation for economically accessible damage, rehabilitation, including medical, mental health, and psychological support, as well as legal and social services, and satisfaction, which covers a broad range of measures, including symbolic acts, such as acknowledgement, apologies, commemorations, and tributes to the victims, and the acceptance of responsibility for environmental harms. The fourth element of transitional justice is guarantee of non-recurrence, which is forward-looking. It aims to prevent human rights violations to arise in the future, which then goes into the area of institutional, legislative, policy reforms in education and culture, to understand and to address the underlying causes of environmental crises, but also the related human rights violations and abuses. While reparations for past harms are fundamental to accountability, it is indeed important to look forward, which means how can we define effective measures to prevent future violations? And I would like to leave with you the idea of what I launched last year, a human rights economy, which in a way seeks to dismantle the root causes and structural barriers to equality, justice, and sustainability. It ensures that business models, economic policies are guided by human rights and place people and planet at their core. Very often, economic economic models almost have a separate life, parallel life to human rights, which makes it very problematic. So the human rights economy concept also advances an equitable distribution of resources that reduces inequalities within and between countries. And I also related to this is the absolute need for all states to live up to their global finance commitments, including for climate change mitigation, adaptation, and loss and damage. And they must go beyond them. We must transform. I mean, obviously, all of these are very important measures, but we need to transform our whole economic thinking, systems, and societies. We issued a recent report on climate change and the right to food, just to give you one example, to show how economic policies, including financial assistance, debt servicing, tax structures, need to be transformed to ensure that polluters pay for the environmental harms they cause. And under human rights law, those responsible for the climate crisis are legally obligated to take the necessary measures to stop, minimize, and remedy its human rights impacts. And the science has long been clear that it has legal consequences for policymakers and political leaders. So your discussions are really critical. I mean, we need to make sure that all efforts are guided by the first-hand knowledge of victims and impacted communities. We know that experiences and grievances of the people who are most affected by the climate crisis, they help us breathe life into legal frameworks. We know that their reality exposes the wrongs that must be made right and tells us how we can do better. We need to hear the stories and the ideas of people in this regard. And facts and knowledge matter. I mean, we have seen, unfortunately, too much pushback on the right to science and evidence-based decision-making. But we also need to emphasize that everyone has a right to access information and the right to benefit from science and its applications. So we cannot protect the environment without effective measures to ensure that those who experience it firsthand have access to this information, to justice, to effective remedy, and perhaps most importantly, a place for their stories and for their demands to be heard and acted upon. Wish you all the very best, and thank you for inviting me.